Good morning. This is the time scheduled in original proceeding 180599, Honorable Steve Bullock versus the Honorable Tim Fox. Counsel ready to proceed?
Respondents ready to proceed, Your Honor.
Mr. Grable.
Mr. Chief Justice, members of the court, my name is Rafe Graybill, and I represent Governor Bullock and Director Williams in this case. I'd like to reserve 15 minutes of my time for rebuttal. I'd also like the court to note a handout we've given both to opposing counsel and to the court. This handout contains some pin citations to cases we may discuss to the extent the court wants to talk about standing. This is a case that turns on two very simple propositions. First, a land acquisition requires the acquisition of land, and a conservation easement simply is not land. Second, the governor and the Director of Fish, Wildlife, and Parks have standing to sue the Attorney General, where the Attorney General has authored an opinion that directly restricts the exercise of their offices. This is not a case about an agency's prior practices, nor is it a case about whose interests are better served by any particular reading of the law. It's a case about what the words mean, about what the law says. First, standing. Montana law authorizes the governor and the Director of Fish, Wildlife, and Parks to put the finishing touches on 3 conservation easement deals that have received final approval from the Fish and Wildlife Commission. The Attorney General in this case has authored an opinion that directly prevents them from doing so. In this sense, the petitioners have alleged an injury that is particularized to their offices.
Counsel, let me interrupt you. Are the deals complete, or are they in the process of being completed?
The deals have received the final approvals that Montana needs to complete them, and what we're prevented from doing is effecting the administrative closure, effectively signing the paperwork and sending the money. It's our position that under Montana law, once the commission votes, the commission gives it a thumbs up, the deals are done, and we can proceed to closure. The Attorney General's opinion in this case acts directly and uniquely on the petitioners here. It is the governor and the director, and only the governor and the director, who have the administrative responsibility for signing the paperwork and sending the money. They can't do that here because of the Attorney General's opinion. Now, to reach the opposite conclusion on standing, the Attorney General proceeds on 2 discrete mistakes of law. First, the Attorney General proceeds on confusion about what courts mean by the phrase personal injury or a personal stake in the context of standing. By this, courts simply don't mean, as the Attorney General would suggest, that only human persons may experience injuries that would undergird standing. What courts mean by the phrase personal injury or personal stake is that the injury asserted by a party coming before the court must match the party. They must have, in the words of the Hollingsworth case, which was cited to you by the Attorney General but not quoted, quote, a direct stake in the outcome. In this case, because it is the governor and the director, and only the governor and the director, who are responsible for effecting administrative closure on these deals, it's clear that standard's satisfied. It's clear they have a direct stake in the outcome. Second, the Attorney General proceeds on confusion about the difference between official and individual capacity suits. The notion that somehow the governor and the director would need to seek the Attorney General's permission in order to file suit challenging an Attorney General opinion would not only fundamentally reorder our separation of powers, it's simply not supported by any case of this court or any court of the United States. It is well established in law that official capacity suits is merely shorthand for saying the office suing. And in many cases, we can talk about them in the handout we provided to you, the United States Supreme Court, U.S. Courts of Appeal, and this court have directly recognized the capacity of officials to sue, invoking their official capacity.
How do you distinguish Raines versus Byrd?
Raines stands for the very common sense proposition that the injury asserted has to match the party asserting it. In Raines, 6 individual members of Congress sought standing to assert injuries that only 535 members of Congress, all members of the House and Senate, could experience. In that situation, the court said, these 6 individual members could not invoke their, quote, official capacity to speak for all 535. But the proposition cited by the Attorney General in Raines, that there's no such thing as an official capacity suit, simply doesn't hold up. Raines applies a common sense principle. The injury asserted has to match the party asserting it. That's easily satisfied here. Now, the Supreme Court and their various other federal courts of appeal have time and again revisited the same principle articulated in Raines, that existed before Raines and after Raines, and have said that in situations where state officials allege injuries that match their offices, it's clear they're standing. One such case is just 3 years ago in the U.S. Supreme Court called Arizona Legislature against Arizona Redistricting Commission. In that case, the U.S. Supreme Court said because the Arizona State Legislature asserted an injury that it could experience, it was clear they were standing. The leading case on gubernatorial standing is called Gutierrez against Pangilinan, and that's again cited in the handout we gave to the court. In that case, the governor of Guam alleged injuries that affected the exercise of his official duties, much as here. Ninth Circuit, distinguishing Raines in that case, said it was clear that governor had alleged a particularized injury that ran to his office and that he had standing to sue. The same principles apply with even greater force in this case. In this case, the Attorney General's opinion is directed at the governor and directed at Director Williams. For some context here, the governor and the director closed a conservation easement deal this summer after it had received all the approvals Montana law requires. That was the Horse Creek Conservation Easement. Only after that deal closed did the Attorney General author this opinion. Now let's make no mistake here, the opinion is directed at restraining the conduct of the two petitioners in this case. And I want to make an additional point on standing here that I think is important for us all to recognize. If the Attorney General's arguments on standing are correct, this court will be adopting two significant consequences. First, if the Attorney General's argument is correct, that he can invoke his power to give legal opinions, and that these opinions can restrain the conduct of separately elected constitutional officers, and yet the opinions are unreviewable as to those officers, that would significantly reorder our separation of powers. In fact, it was a similar situation that this court addressed in 1984 in the Montana Power Company against PSC case, which is the last case cited in our brief, in which this court said that if the Attorney General could do that, could override the discretion of other separately elected officials anytime questions of executive power touched the law, that would render the Attorney General a super officer. And the court declined to extend that proposition.
So, speaking of separation of powers, Article 6, Section 4 of the Constitution states, 1, executive power is vested in the governor. And then it goes on to say, who shall see that the laws are faithfully executed. Doesn't that provision alone give the governor standing?
Correct. I think that provision alone is the heart of what the standing argument is here, is that under the Constitution, the governor and his agents like the director have a direct constitutional charge to implement the laws of the legislature. And where a separately elected official interferes with their ability to do so, it's clear that we can say the governor has a direct stake in the outcome. Unless there are further questions on standing, I'd like to move to the merits. It is a first principle of statutory construction that when examining statutes, courts presume that legislatures say what they mean and mean what they say. And in situations like this one, where you have an undefined term that's at issue, we know what to do. Courts begin with the plain text of that term. And where the plain text yields an answer, the inquiry ends. In this case, the term land acquisition simply does not encompass conservation easements, because conservation easements aren't land. And I think it's helpful at this juncture to step back for a second and clarify exactly what a conservation easement is. There's nothing special or exotic about a conservation easement. It's merely a deal or negotiated transaction between two parties that places a negative servitude on one party's land. The party that owned the land before owns the land after. If she'd paid taxes on it before, she pays taxes on it afterwards. In this case, typically she continues to live there, operate a family ranch operation there. That's all that changes. In that sense, it's structurally or legally no different than if I didn't like my neighbor's tall trees, and I paid my neighbor some amount of money every year not to have her trees above 20 feet high because I didn't like the shade or something like that. And if we went down to the courthouse and recorded that, that'd be a negative servitude on her land. But in that situation, we'd simply never say that I'd acquired my neighbor's land or that I control my neighbor's land. I might have acquired an interest in it. I might control an interest in it, but I simply haven't acquired it. I don't control it in whole. And when the legislature intends to include in the sweep of its provisions interests in land, particularly like this interest here, conservation easements, which are non-possessory interests in land. It knows how to say it. It said it in Section 301 when it said the Fish and Wildlife Commission shall approve all interests in land. It didn't use those terms in Section 209. It used the term land acquisition. We have to give meaning to that difference. Now, I think it's also important to note that throughout Montana Code, every time the legislature says the word land acquisition, it intends the actual acquisition of land. Take, for example, Title 17. Title 17 requires a biennial report from the Department of Administration through the governor to go to the legislature. And they've got to report on all of the land acquisition used in the last 2 years to advance the interests of the long-range building program of the state. It would stretch our imagination to envision a situation in which the Department of Administration would acquire a lien or a usufruct or a conservation easement or any other non-possessory interest in land to build a building, to build a courthouse or a prison. In Title 16, there's a provision about the marketing of cigarettes in the state of Montana. And cigarette manufacturers, or cigarette marketers, are able to take out of their cost of doing business land acquisition costs. Again, it would stretch our imagination to come up with a situation where the marketing of cigarettes required a conservation easement or another non-possessory interest in land.
Counsel, what is the purpose of requiring land board approval for land acquisitions greater than 100 acres or 100,000?
I think a couple things. I think if we go, I don't think we have to go to legislative history to see this. We can. But I think the purpose of requiring land board approval is that when you have private land become public land, overnight there are several distinct externalities. One of them is you take all that land out of the tax base. I think we see this in the legislative history. Again, we don't need to rely on that. But I think it's clear at the time the legislature was concerned about removing this land from the tax base. But however you characterize it, with a conservation easement, the land begins as private and it ends as private. So the third party implicated there, the county, and its ability to tax, simply doesn't come up. And given that that was the legislature's objectives at the time, it makes sense that they would use the phrase land acquisition, which has a well-established meaning in the code, and would decline to use the other phrase interest in land. Now, it's important to note that at the time this statute was amended, Section 301 existed in its current form. Section 301 said interest in land. So we know at the time the legislature had text it could use to describe the broad sweep the Attorney General wants to accomplish, but they chose something else, and we have to give legal effect to that difference.
So, counsel, you're saying that the purpose for that requirement is strictly related to tax base and protecting that?
I don't know if I'd go that far. I would say that it's limited to land itself. I think that's where the plain text leads us. It limits it to land itself. Take this, for example. If we removed the word land from that statute, we wouldn't have a case. This case would be over. The Attorney General would win because it would say in the case of acquisition. But the fact that the legislature chose to insert the term land grounds our discussion, and we have to give legal effect to that decision. Now, it's clear throughout the code that when the legislature intends to to cover this broad sweep of activities, both land itself and lesser non-possessory interests in land, it also has the language to do so. And we didn't include this in our brief for length reasons, but even a simple Westlaw Alexa search reveals there are dozens of times in the code when Montana uses the phrase interest in land. And there's even statutes that distinguish land from interest in land in the same statute. For example, in Title 75, if the Department of Transportation wants to build a junkyard, it can acquire land or an interest in land. Now, for the Attorney General's argument to be right, one of those words has to be surplusage. And that simply isn't the rule this court follows. I think it's important also for the court to focus on the portions of the Attorney General's opinion that actually analyze the text of the statute itself. That's paragraphs 13, 22. The Attorney General's analysis of the statute's text itself, and we can talk about names of federal manuals and 1940s Ohio cases later. I don't think those answer the question at hand. But when the Attorney General analyzes the text of the statute itself, the question he poses on paragraph 12 is the term land acquisition, his term, synonymous with interest in land? And in paragraph 18, his answer is yes. And in the response brief, he doubles down and says yes. He describes those two different terms as, quote, a distinction without a difference. That simply doesn't conform with this court's rules for interpreting statutes. There are problems that follow throughout the opinion as a result. First, the logic to get there, to conclude that two different terms actually, accidentally mean the same thing, simply doesn't follow. This is in paragraphs 16 and 17 of the Attorney General's opinion. And this is the logic, and I am not being uncharitable. The logic is this. In real estate law, there are many specific terms. The terms the Attorney General consulted didn't have a definition for the phrase land acquisition. Therefore, land acquisition is a generic term. Therefore, it's the same as another generic term, interest in land. That simply doesn't follow. All bicycles are made of metal. All cars are made of metal. All cars are bicycles. That logic simply doesn't follow. And the effects are felt throughout the opinion's analysis of the text. Later on, in paragraph 28 of the opinion, when confronted with the effect of Section 301, which uses the phrase interest in land, the Attorney General's stuck. He's got to get around the fact that the legislature does have terms to describe interest in land. It's the term interest in land. Well, the way the Attorney General gets around Section 301 is to say, well, the rule of meaningful variation, that canon of construction applies, except for when there's variation. And we have to ignore Section 301 for the Attorney General's argument on the text to be correct. And that simply isn't the way this court analyzes statute.
Counsel, without any disregard for the technical arguments that you're making, and with all respect to both parties, this is a simple legal case that's pretty straightforward the way I see it. And we'll decide it on those grounds. But what's going on here? Why is the Attorney General and the Governor fighting over the interpretation of these statutes? What's the larger game at play here?
Thank you, Justice Sandifer.
And I take your point, Justice.
I didn't know we could ask questions like that.
Well, actually, we can.
And Justice Sandifer,
I don't have to answer it, but I want to know what's going on here.
So I take and I emphasize your point that the question before the court is discrete, it's legal, and I would put forth to the court it is rather straightforward. If you follow the rules, they support only a single reading of the statute. Now,
we will, but what's going on here?
At the heart of this case is whether or not we can administer the Habitat Montana program. Now, again, this court doesn't have to decide questions about who was right and who was wrong at any given time. But I think it's a matter of public record that in this case, there were issues around whether or not certain conservation easement deals, which had received all of the approvals Montana law requires, can go forward or not. And I think, again, it's important to remember this court's decision on the merits, though it will be limited, as I understand, just to the statutory text, will have real-world effects. And tied up in that are dozens of families who rely on this program, hundreds or thousands of hunters and anglers that rely on the public access this program provides. So the court's decision has real-world consequences, but
seems to me there's a different issue that this is really about, and it's about which executive officer has authority, if you will, in the executive branch to, in this case, operate the Department of Fish, Wildlife, and Parks. And it seems to me the question that we're asked to interpret is back to Article 6, Section 4, which says the executive power is vested in the governor. If you go back and you look at the transcripts of the Constitutional Convention, that was an incredibly big issue at that time. Prior to 1972, that was not the case. The executive power was spread among numerous boards and other entities that had various executive powers. It seems to me that since the creation and adoption of the new Constitution, the question is fairly clear. The executive power is vested in the governor.
I think, Your Honor, you're right. I think this case can begin and end with that question or with that provision. I think
Seems to me it can.
I think particularly on the standing question.
Mr. Grable, is there any impact from the statute 87.1.105 that says the Attorney General of the state is the legal advisor of the Department of Fish, Wildlife, and Parks and shall, together with the several county attorneys, enforce the provisions of this title?
I think that would raise a very similar situation to the Montana Power against PSC case in 1984. In that case, the Attorney General was also by statute the legal advisor to the PSC. And this court was very clear in its holding there that despite being the legal advisor, the Attorney General could not invoke that authority to override the substantive exercise of executive power. Couldn't, in that case, make rate decisions. Those were properly reserved for the PSC. I think the same is true here. And we wouldn't want to go to a situation where by invoking doctrines like standing or by invoking statutes like this one, the Attorney General could say, though I am the lawyer and you are my client, I can override your client decisions because this is my view, and the Supreme Court of this state can't review it. But I think that's basically the argument the court faces here today. I want to make one other additional point, which I promised the Attorney General I would bring up, which is that, as the court well knows, in our petition, we noticed that there were 3 deals that have been approved now. One of those deals had a November 30th deadline. That deadline has passed. Fish, Wildlife, and Parks was able to work with the owner of that property. They were able to obtain a brief extension in light of this argument. The other 2 deals remain unchanged. Time is still of the essence for that owner. But for that reason, we are deeply appreciative of this court setting arguments so quickly and hearing the case.
When are the other 2 deadlines, and how long has the first one been extended?
The first one, like a lot of these deals, he's got multiple transactions as part of his estate planning tied up together. So when he gets the conservation easement money, he'll use that to buy an option on land near him, if it's next to him or near him. That option date is expired, but his neighbor has said, I know the case is going on, I know we're going to get a final decision, I will work with you. Now, I believe there might be another buyer in line for that, and so he's sort of in the good graces of his neighbor right now. One of the other deals has a tax deadline at the end of the year. The other one, without blowing up his details in public, has a foreclosure issue that he's facing. So time is of the essence for each of these deals. And I think the farther down we go, and this is why we're so appreciative, there is a whole pipeline of these deals coming up. They take years to negotiate, years to complete. Families invest lots of money in these deals before they go forward. And the farther we go, the more Fish and Wildlife Commission votes there will be that approve deals, and you'll add to the set of questions before us now.
Counsel, on page 8 of your brief, you state, petitioners maintain that the deals are already complete and the Attorney General's opinion will hold that they have been vetoed. So I guess, can you explain that statement in the context of what you've just said, which is that they're not complete and we need an expedited review to complete the process? Or are you asking that we prevent the Attorney General from vetoing those deals?
Yes, Justice McKinnon. So the process, as I understand it, is you get a series of approvals. Imagine buying a house, for example. The Fish and Wildlife Commission is like the home buyer that says, yes, we want to buy this house. And Montana law, in our view, says the Fish and Wildlife Commission gets to make that final decision. Is this a good deal or a bad deal? Once the Fish and Wildlife Commission has endorsed a deal, our view of Montana law is that the sort of approval, what the Attorney General calls the political approval, is over. It then turns over to the Department of Fish, Wildlife, and Parks, acting through the governor, to sign the paperwork and send the money. In this case, without review, we'll have 3 deals that we believe have received all of the approvals on the Montana side. They need to be completed. But the actual administrative completion, the executive tasks of signing the paperwork and sending the money, those can't go forward because the Attorney General's opinion intervenes and says, no, you have to take this extra step, not founded in law, and go back to the land board. I'd like to make one other point that I think is helpful here. The Attorney General, in his response brief, focuses in on the word control and says that we neglected to include the word control in our brief. Now, one, I think the operative term here is land. Again, if you take land out of this statute, there's no case. The fact that land is in there is important, and we have to give legal effect to that. But I think the word control actually helps our case, and we actually did include it in our brief. But it helps our case. Because go back to my example of my neighbor with the tall trees. Now, if I pay my neighbor not to have trees above 21 feet high, we wouldn't say that I control her land. We'd say I control an interest in her land. And the same is true for conservation easements. The holder of a conservation easement, in this case the state, controls an interest in the land, not the land itself. And again, the legislature has been very clear. When it wants to include this broad sweep of interests in land and land itself, it knows how to do so. It didn't do that here. Unless there are further questions, I'll reserve the remainder of my time.
Before you sit down, counsel, let me ask you a question about the statute. You opened by saying you thought the issue was whether a conservation easement was a land acquisition. I think the issue is what does the statute mean and provide, which may not require getting into esoteric arguments about property law. But let me give you this reading and get your response. The statute's a little clunky and could have been aided by a couple commas, but here's what I think it means. That the commission may acquire by purchase, lease, agreement, gift, or devise. It would have been nice had there been a comma right there. And may acquire easements upon, and again, would have been nice to have a comma there, lands or waters for the purposes listed in the law. So it seems to me that the commission is authorized to acquire lands, acquire waters, and acquire easements upon land and waters. And if that's what the statute is authorizing, those three things, then the insertion of the clause, and in the case of land acquisition involving more than 100 acres or $100,000 in value, you must also have the approval of the land commissioners. It seems to me that the additional clause sends one of three kinds of transactions to the land. No one's made that argument, but I'm wondering what your response to that would be.
Justice Rice, I think there is a good argument that the separate addition of or acquire that modifies easements upon would separate easements and that this land board provision doesn't apply at all. Now, neither side makes that argument because there are other stories you can tell about the statute in which land acquisition applies across the board. And the reason that we don't make that argument is because even under the most demanding reading of the statute, that is that land acquisition applies to every kind of property relationship described, it still doesn't cover conservation easements. And again, the relief we're seeking here is a very narrow holding. We're not asking the court to come up with a test for all time as to what land acquisition means. I think that's clear. We're asking for a holding that land acquisition in this statute doesn't include conservation easements. And I think even, again, under the most demanding reading of the statute, a conservation easement remains different from land. I'll reserve my time.
Mr. Cameron?
Thank you, Your Honor. Chief Justice McGrath, Associate Justices, may it please the Court. My name is Rob Cameron, along with co-counsel Melissa Schlichting. I represent the Attorney General today. The 3 points I'd like to cover today, if I may, are first, contrary to what we've heard and read in the briefs, the Habitat Montana program is alive and well under the current land board. Second, neither Petitioner Bullock nor Petitioner Williams has even so much as alleged an injury, in fact, affecting either of them in a personal and individual way, hence they have failed to meet their burden of establishing standing. And finally, and I think dispositive here, the Fish, Wildlife, and Parks documents and a consistent, long-standing, quarter-century practice of construing land acquisitions as encompassing conservation easements, as the term is used in Section 209, conclusively removes any doubt as to the meaning of this phrase, land acquisitions. However, first I'd like to touch on the issue of original jurisdiction. In our written response to the petition, we took no position on whether original jurisdiction is appropriate. Since the filing of our response, though, as counsel has candidly acknowledged, a significant development has occurred which bears on the emergency or urgency factor specified in Rule 14. Specifically, in page 8 of the petition in this case, the one easement that they maintain provides this urgency or emergency factor is that easement that at that time faced a end of November deadline for completion. And as council has acknowledged now, that deadline no longer exists. In fact, a substantial question exists based on what council represented today as whether any hard and fast deadline with respect to that easement even exists at all, as the other participant in the transaction has indicated a willingness to work with the person pursuing the easement.
I assume you would acknowledge, though, that land transactions similar to this, whether they be an easement or a fee title, often have considerable tax standing and have oftentimes urgent deadlines for people in the process.
Well, I hesitate to go.
Other than taxes.
I'm sorry, Your Honor. I hesitate to go there. In my 25 years of practicing law, I have run, not walked, away from tax issues when it comes to the practice of law. So I personally can't attest to all those implications of tax consequences in light of the fact that we do not know what those facts are in this case. However, the question before the court is, are such tax consequences really such an urgency or emergency factor? The fact that a participant in a real estate transaction might have to wait until 2019 to enjoy a tax benefit, if that is in fact the case, does that really truly rise to the level of justifying original jurisdiction? That is a question for the court. More importantly, however,
well, before you move on from that, is it your position then that we should defer and require this suit to be brought first in a district court?
That is certainly Your Honor's prerogative, especially in light of their insertion of this Jim Flynn declaration and numerous exhibits attached thereto, where they did in fact insert many fact issues. They allege that this is purely a legal question, but in support of their legal arguments, specifically on the long-term practice of fish, wildlife, and parks, which I note counsel did not even mention during his opening remarks, in order to justify their position in that regard, they did interject quite a number of facts. So I think the answer to that question is the proper course would be for the court to either strike or completely disregard that superfluous bunch of factual information, or, yes, remand to district court for further fact-finding, giving us a chance to depose Mr. Flynn, to actually engage in fact-finding, since they have interjected those facts into the...
But as I understand the Attorney General's position, you agree that the merits of the issues are purely ones of statutory interpretation.
That's correct, Your Honor, that we believe that the simple construction of land acquisition should resolve the matter without regard to this superfluous affidavit of Mr. Flynn submitted recently.
So, counsel, on the other requirement for original jurisdiction, that there be an inadequate remedy on appeal, can you address that?
Well, I think the two concepts go hand in hand. The fact that there's no adequate remedy at law at the district court level goes to the fact that they would suffer apparently some significant financial loss, which is a related concept, of course, to the idea of the emergency or urgency factor, that the normal course through the district court would not provide them an adequate remedy. Now, more specifically, though, I think what's controlling on the issue of original jurisdiction is this. This urgency or emergency factor that they're claiming here is absolutely, positively, 100% of the petitioner's own creation. The three easements at issue, the first one, Birdtail, was approved by the Fish and Wildlife Commission back in April of this year. And they could have submitted that conservation easement to the land board for approval at the May, June, July, August. In fact, they could submit that one and the others at the upcoming December 17th land board meeting. And they have failed to do so. The two more recent conservation easements were passed by the Fish and Wildlife Commission, were approved by the Fish and Wildlife Commission in October, and so they certainly had Oh, and this is really interesting to me, that at the October Fish and Wildlife Commission meeting, 4 Habitat Montana projects were submitted to the Wildlife Commission, 2 conservation easements, and 2 fee title acquisitions. All were approved by the Fish and Wildlife Commission. However, when it came time to transfer them to the Land Board for final approval, Fish, Wildlife, and Parks submitted the fee title acquisitions under the Habitat Montana program, which were immediately at the Land Board meeting approved and finalized. The deals were consummated with respect to the fee title ones, but they held back these conservation easements, notwithstanding the fact that they have acknowledged that while they disagree with the Attorney General opinion, until such time as the court or the legislature overrules it, they're bound by it. Therefore, they don't like it, they think it's bad law, but it's the law, and they acknowledge that. One thing they have completely failed to even address is, given the fact that the AG opinion is currently operative, why in the world have they not just gone ahead and submitted these conservation easements to the Land Board for approval? They could, of course, preserve the right to say, we disagree that this is a legal requirement or should be, but in light of that Attorney General opinion, we're doing it anyway. Just to cover our bases here, we do not concede that this step is necessary. They could do all the things that we lawyers do to preserve their arguments and still submit these to the Land Board. When you read their petition and look for a reason why they haven't submitted these to the Land Board in these many months, the answer appears to be the Land Board might say no. And then they'd be in the same position they are today. The reason that argument does not hold water is the current Land Board has never, ever voted down a new conservation easement. It has not happened. I mean, we read the briefs and there's this hysteria about submitting these conservation easements to the Land Board is, in the words of one of the amici, a catastrophe.
So, Counsel, are you saying that there's 3 conservation easements currently at issue?
Correct, Your Honor.
And that none of those conservation easements have been submitted to the Land Board for approval?
That's absolutely correct, Your Honor. And one of them was approved by the Commission, Fish and Wildlife Commission, way back in April. And there have been all these Land Board meetings that they very easily could have submitted these conservation easements.
So are you saying the Land Board has never voted to table a request for one of these easements?
Not at all, Your Honor. What I indicated was they never voted one down. What happened with Horse Creek is simply a case where the Fish and Wildlife Commission approved the Horse Creek complex conservation easements. There were 2 easements involved in that transaction. The Fish and Wildlife Commission approved it on a Thursday. Then there was Friday. Then Monday was a holiday. Then Tuesday was a Land Board meeting where they are faced with not the final versions of these conservation easements, but drafts. So at that point, some of the Land Board members said, we need more time. We have questions about the validity of the appraisals. So Attorney General Tim Fox at that time took the lead and moved for approval of the conservation easement, the Horse Creek conservation easement. And Governor Bullock followed suit, followed Attorney General Fox's lead in that regard, and the 2 of them both wanted that easement approved on the spot, but the 3 majority members of the Land Board said, we need more time. So they voted to postpone consideration of it. And then what happened, instead of it being brought back to the Land Board, Fish, Wildlife, and Parks and the governor just unilaterally went forward and closed on that easement, and then told the Land Board after closure, you don't need to analyze Horse Creek anymore. We've already consummated that transaction. That's what happened. So the fact that the Land Board in that instance said, we would like a little more time to analyze this $6.1 million land acquisition is really not surprising, and I would submit not unreasonable. So, but this current Land Board has never voted a new conservation easement down. Now,
So, Counsel, with respect to that Horse Creek property, what remains for the Land Board to do with that? That was my question to council before. In other words, there is still administrative things that take place, and that there's still an opportunity for, as in the petitioner's words, the AG to veto that conservation easement.
Well, the AG has done nothing of the sort, has not even indicated that the Horse Creek easement should be vetoed. The position of the AG would be, in light of the statutory language requiring land acquisitions, which we, of course, include conservation easements, to be submitted to the land board, I think the proper course at this point would be submission of Horse Creek to the land board for the land board's ratification. Would clear up any confusion at all on the issue. At this point,
Answer to the question that Justice McKinnon is answering, though, you would acknowledge that there is a cloud, that the AG's opinion is a considerable cloud on the validity of the transaction.
I think that's fair to say, Your Honor, yes. I believe it does. I mean, if I was involved in a transaction like that or advising a client in that regard, there are options such as quiet title proceedings. But the first and most obvious step would be to say, Fish, Wildlife, and Parks, you skipped a step in the process. Please submit it to the land board for ratification, and that would put to rest any potential cloud on the title. So again, the idea of none of these easements having been submitted to the land board for approval actually is the reason why they're claiming, now here we are many months later with this emergency situation, this urgency factor, which could have been avoided had these easements been submitted to the land board in a timely manner. Fish, Wildlife, and Parks, frankly, failed to do so. And that's why they're alleging original jurisdiction's appropriate, and we would respectfully disagree with that point. And again, what I'd also like to make sure we touch on during the limited time, a couple of observations regarding the long-standing practice of Fish, Wildlife, and Parks, which again is an issue that has not really been addressed by counsel. And specifically,
isn't that a question of fact?
Not exactly, Your Honor, because in the Montana Power case itself, what the Montana Supreme Court had indicated is when the meaning of a statute is placed in doubt, that the proper course is to examine what has been the long-standing, continuous, unchallenged practice. In this case, it's a quarter-century long-standing practice of Fish, Wildlife, and Parks to treat conservation easements as land acquisitions and submit them to the land board accordingly. And Governor Bullock, the petitioner in this case, himself, as a member of the land board, has in fact sat on numerous land board votes on conservation easements without ever saying, wait a second, I'm the chief executive here, and land board approval is not necessary. In fact, he was an active participant in land board votes on conservation easements. And this is a process that began a quarter century ago.
So is it your position, Mr. Cameron, that the statute is ambiguous?
Not necessarily, Your Honor. Our position is that the phrase land acquisition is not ambiguous, that it does clearly encompass acquisition of fee title and acquisition of conservation easements as well.
We would only look to the practice of the commission and the department if we determine that the plain meaning of the statute doesn't resolve the question. Is that correct?
Well, again, the actual language in the Montana Power case indicates that it does not have to rise to the level of an ambiguity in order to look at the long-standing administrative practice. In fact, the exact language used by the court in Montana Power was whenever the meaning of a statute is placed in doubt. And clearly the petitioners have placed the meaning of the statute in doubt. And that's why we believe it's important to look at this quarter-century, long-standing, unchallenged practice of the Fish, Wildlife, and Parks, beginning, as we've indicated in our brief, Exhibit B to our Attachment 1, an April 1992 letter from Fish, Wildlife, and Parks to the Department of State Lands in which Don Childress, Administrator of Wildlife Division, says, and I quote, Statute 87-1-209 requires approval of this easement by the Land Board. If Fish, Wildlife, and Parks Commission decides to purchase the easement, we would like such approval, and we will advise you of the outcome of the April 16th Commission meeting regarding this item and whether or not this agenda topic needs to be carried to your April Land Board. Because at that time, in 1992, the process for getting items on the Land Board agenda was to go through the Department of State Lands. Now they go through the DNRC, of course. So,
Sorry.
You go ahead.
I'm just wondering, then how do you reconcile what the language of the statute, land acquisition, with the multitude of other statutes that we've been pointed out that talk about interests in land? And there seems to be a clear distinction that the legislature seems to understand that they are different. Even in the implementing ARMs with ARM 12.9.512, subsection G, in setting forth the policies and the rules to implement this habitat program, talks about easement or lease being way different than a fee title in land. So how do you reconcile all that?
Quite easily, Your Honor. Actually, in the primary argument that counsel has raised in this regard is to compare 87-1-209, our statute at issue, with 87-1-301. And their argument there is that because they said all acquisitions of interest in land encompasses easements, therefore the phrase land acquisition cannot encompass easements because they use different language in the two different statutes. The answer to that question is they were talking about two separate concepts. 87-1-301 must be read in its entirety, and I would caution against reliance on the petitioner's brief because they have not always consistently set forth the full text. They did in their appendix, so I give them credit for that. But what the full text of 301 is talking about is all acquisitions or transfers by the Department of Interest in land or water. That's a very broad concept. Whereas 209 is sharply limited to only land acquisitions involving more than 100 acres or $100,000 value. A very, very much smaller subset. So the fact that they use different language in the two different contexts is not really surprising since they are talking about two different concepts.
Well, I think you've hit on an important point there, and to get back a little bit to Justice Rice's question in the previous argument, if we only look at 87-1-209, it separates out different types of interests right in the body of that statute. The clause that is set apart by commas refers only to land acquisitions, and later in the same statute it says, and may acquire easements upon lands and waters. So do we need to look beyond the language of this statute to determine what is meant by approving, by the land board having to approve certain land acquisitions?
I don't think so, Your Honor. And again, that's because our interpretation, our construction, rather, of land acquisition clearly includes it. Now, one point about the statute, 209, Justice Rice, I think, correctly described it as clunky. I believe that might have been a little on the generous side, frankly. This is not a model of clarity. We recognize that when you read the statute 209 sub 1 as a whole. In a former life, I was an English teacher, and when I read this, I looked at this and I said, there are two uses of the verb phrase may acquire. They're both what are called transitive verbs, which means they need to have a direct object. That is a noun or pronoun. I'm sorry to get so grammar geeky here, but they're supposed to have a noun or pronoun following the action verb that receives the action of the verb. And in this case, what we have is a transitive action verb may acquire with no direct object. It just kind of leaves that question a little bit dangling out in space. It does, so it should So we can only speculate as to what the legislature intended to receive the action of the first may acquire. I'm sorry if that's a little.
But arguably, the direct object would have been lands and waters for the first may acquire, which would have been clear had there been the commas.
That would certainly be one way of construing it. What I would submit is dispositive on resolving the resolution of this statute is to look at the final two prepositional phrases that are listed here. For the purposes listed in this subsection. Now, that immediately follows acquire easements upon land or waters. And if we carve out easements upon land or waters as a sole and separate thing, then those prepositional phrases would only apply to easements, which means that the laundry list of purposes for which these land acquisitions can be made would be limited to conservation easements, and other land acquisitions such as fee title acquisitions would not be subject to the purposes listed in the subsection.
So it seems to me you're making the argument that this is an ambiguous section.
Well, as the Attorney General opinion said, if the court concludes this...
Monkey, but not ambiguous?
Well, ambiguity to some degree, Your Honor, is in the eye of the beholder, and we would certainly not have any particular issue or objection should the court find, as a whole, we have an ambiguous statute here. And when we go there, that takes us directly to this unbroken, long-standing practice. This document is called the Fish, Wildlife, and Parks Report to the 65th Montana Legislature. It's part of the record at Appendix 1 to the amicus brief of the Public Land and Water Access Association. And what it tells us, remember back in 1992, we had the letter from Childress that unequivocally told the Department of State Lands that, of course, conservation easements are included in the statute. Of course, conservation easements need approval by the land board. Now, here we are 25 years, quarter century later. Here's a report dated January 2017 from Fish, Wildlife, and Parks to the legislature. And here's the representation we find there on page 12. This is on wildlife land projects, generically Habitat Montana, and other funding sources. And I quote, "The following section summarizes all land acquisition projects, conservation easements and fee title, which were completed for wildlife conservation during calendar years 2015 and 2016. So, and again, grammatically, the phrase conservation easements and fee titles are an appositive that rename the subject projects, land acquisition projects. This tells us there are two types of land acquisition projects, conservation easements and fee title acquisitions. And then when you actually read the report, there are two tables. The first one under this land acquisition description, conservation easements. The second one, fee title land acquisitions. Now, why would they have to say fee title land acquisitions? To distinguish them from conservation easement acquisitions. And that's why, and so we have this unbroken, unchallenged practice of Fish, Wildlife, and Parks.
Counsel, can we get to the purpose of requiring land board approval for certain types of acquisition?
Yes, Your Honor. When we look at the legislative history on that, I guess what we see are, I would very readily acknowledge the primary concern of the legislature in inserting this land acquisition involving more than 100 acres or $100,000 in value. A primary concern was erosion of the tax base that was occurring when Fish, Wildlife, and Parks was acquiring fee title to lands for conservation purposes, taking them out of the tax base. And local governments were complaining about it. That was an issue. And that supports the notion that land acquisitions do include fee title acquisitions. But when we look further into the legislative history, we see a couple of important points. First, we see that that was not the only concern. And that's why we quoted from then-Director Jim Flynn's testimony, written testimony that he submitted to the land board. This is in both the AG opinion or not to the land board, but to the legislature rather. And what he said was he opposed addition of this language. Why? Because it would interfere with the department's ability to acquire conservation easements. So that was the then Director of Fish, Wildlife, and Parks. Now, when we read his current affidavit, we see he backpedals from that position and says, well, conservation easements were new. If I knew then what I know now, I wouldn't have said that. And that he goes on to say, in fact, that he finds that land acquisitions are not conservation, the conservation easements are not. But see, that's completely irrelevant, because what matters is what did the legislature hear? What was the legislature's understanding at the time? What his change of opinion 30 years later has no relevance. What is relevant is what representations did he make to the legislature? What was in the legislature's mind when they passed this? And they passed it with the understanding, because Director Flynn told him, that this land acquisition language applies to conservation easements. And so he was saying, don't pass it, because that'll make it too hard to get conservation easements.
So let's assume then for a minute that the statute is ambiguous, which seems to me to be the bulk of your argument. Don't we have to begin our analysis and maybe bottom the decision based on provisions of the Montana Constitution that seem to be quite specific in terms of executive power?
To a significant extent, yes, Your Honor, but I have some thoughts on that issue as well.
So I'm just saying that maybe the language of the Constitution might have more impact on our decision than testimony of various individuals when the legislation was passed.
As well it should, Your Honor, as well it should. Just a couple of follow-ups on Your Honor's observations with respect to the Constitution in Article 7. Now, one thing that's interesting about our Constitution is our Constitution enumerates numerous powers of the governor. But when it comes to the Attorney General, specific enumerated powers are not spelled out in the Constitution to the same degree that they are spelled out with respect to the governor. So what that leaves us then is to turn to the statutes.
Oh, what it leaves us is the Constitution says the executive power is vested in the governor, period. So it doesn't leave much else. There are other statewide elected officials that are provided for in the Constitution, and it has very limited duties for those statewide officials. And then there's a separate provision that provides for the land board and the membership of the land board.
That's correct, Your Honor, but it's also important to understand the context of the Constitution and that provision.
It is, yes.
Because at the time of the Constitution, the drafters or the framers of the Constitution were faced with two competing arguments. One argument was that the Attorney General ought to be appointed by the governor. The executive committee of the convention, and I'm sorry, Your Honor, I see my time is up. I would like to finish.
Go ahead, finish your point.
Thank you. So what happened at the Constitutional Convention was the executive committee to the convention, its committee report recommended that the Attorney General be a separate, independent office within the executive branch. And the minority report said the same thing. However, during floor debates, I believe it was Delegate Kate, if I recall correctly, raised the question, oh, wait a minute, things would work a lot more efficiently if the Attorney General was appointed to put under the direct authority and answer directly to the governor, and that would make things work better. After a lively debate, the delegates soundly rejected that concept, saying, we need an independent Attorney General whose loyalties are exclusively to the people of Montana, not to his or her boss, that is the governor. So that was a conscious decision made by the legislature to give the Attorney General independent executive power.
Okay.
Thank you.
Your time has expired. Thank you.
Mr. Grable. Please the court. Facts practice, and ambiguity. Let's talk about them. Beginning with ambiguity. An ambiguous statute is one that is susceptible to two reasonable readings. In this case, the court knows precisely what to do when there's a term at issue that isn't defined. And if we follow those well-established rules, there is only a single supportable reading of the meaning of the phrase land acquisition. Now, what you didn't hear from the Attorney General were arguments about the meaning of the text of the statute. It's apparently now the Attorney General's opinion, contrary to the brief and contrary to the original opinion, that this is an ambiguous statute. That's not the conclusion reached in the legislative history section of his opinion. And I think it's important to go back to when the Attorney General actually undertakes to make sense of the text of this statute. What's the argument they concluded? What's the argument they use? This is in paragraph 12 and paragraph 18 of the original opinion. And this is the argument. Two separate terms, land acquisition and interest in land, are, in his words, synonymous. The court didn't hear an argument why we should turn off the canon of meaningful variation. The court did not hear an argument about why two different terms, despite consistent uses in statute, uses throughout the code, should be treated as the same here in Title 87. And in fact, precisely because Section 301 uses this separate language, interest in land, we would expect the canon of meaningful variation to be at the height of its operation in these two closely related statutes. And the idea that encompassing the interests of water somehow changes Section 301 simply doesn't hold. 209 permits the department to acquire water as well. That's not an argument to turn off the canon of meaningful variation. You simply haven't heard one. On the issue of practice, I want to make this very clear. Custom and practice can never ripen into a statutory mandate. Now, there's no question that FWP applied this statute in inconsistent ways over time. For the first 11 years, it didn't take these deals to the land board. Sometime after that, the practice changed and they went to the land board. That's not the question before the court. The question before the court is, what does the law say?
Was there any precipitating event that caused that change in the practice?
Justice Shea, though, you don't need to rely on it. We've worked very hard to find out why that change happened. We worked with the Attorney General trying to search this out. The best we came up with are the two memos we submitted to the court in the 80s where they looked at this and said, these two kinds of things are different. We know it changed in the 90s. We're not here to say there was a good reason for that. We're here to say the law is very clear on it. And if the Attorney General wants to require the governor to undertake an extra unlawful step, he can't do that.
Well, counsel, you didn't have the conservation easement rise before the 90s. Isn't that right? I mean, conservation easements came subsequent to, or later. And I guess I'd like for you to address that, and then also the expenditure of huge amounts of money towards conservation easements, public monies that don't go through the land board as being potentially a purpose of that requirement for land board approval.
Yes, Justice McKinnon. So first, there were conservation easements in the 1980s that did not go to the land board. The Elliott McKinstry conservation easement, the Rock Creek conservation easement, those were the subject of those two memos you submitted. Those and others were finalized after the Fish and Wildlife Commission approved them. Now, you could ignore the Flynn Declaration. It's not necessary for this court's holding. But what we know from the Flynn Declaration is that the Attorney General's assertion in his opinion that this was an unbroken practice for 37 years is factually untrue. It doesn't give rise to a fact issue in this case that would deny jurisdiction. But it's simply not true that the FWP used this in one particular way over time. The question for this court is discrete, it's legal, and if the court follows its well-established rules for interpreting statutes, it can only support a single answer. Now, I'd like to talk very briefly about the legislative history because, again, though the court need not rely on it, there's an important point to clarify here. And I think the amici are very helpful in clarifying this point on Jim Flynn's testimony. Jim Flynn did not go to the legislature and say, it is my belief that the words land acquisition include conservation easements. Read his testimony. It's short. It simply doesn't say that. His testimony was on a different bill that would have required biennial approval by the legislature of any land acquisition deal, a fee acquisition, was that he said, if I have to go out there and tell landowners that every 2 years I can get approval, I will pay such a price premium on those deals that it will crowd out my funding for other things my department does, including conservation easements. Now, if you just read the response brief, if you just read the Attorney General's opinion, you might conclude that he was opining on the meaning of those two words, and he simply wasn't. And I think it's precisely this kind of analysis that undergirds both the opinion and the brief. And I would urge this court, take the propositions cited and measure them against the cases, measure them against the evidence. Now, this court doesn't need to rely on any facts to resolve the discrete question here. Does the term land acquisition require the acquisition of land? And by following simple, well-established rules of construction, there is only a single supportable answer. Yes, it does. And a conservation easement is not land. One other issue I'd like to address very briefly is this new issue of whether this is an appropriate Rule 14 case. Now, the Attorney General had opportunity for briefing in this case, and not once in that briefing did the Attorney General suggest that this was not an important issue for the court to hear, that the court couldn't decide it on legal questions alone, or that there wasn't a time urgency issue. Now, we tried to do what we think the court would expect us to do, and when the deadline for this one deal passed, we sought to help that landowner move out and be able to get an answer from this court and not have the deal fall apart. Now, it's interesting that the Attorney General, in newly raising this Rule 14 argument, won't go so far as to meet the actual requirement of, this is a third-prong Rule 14, which is district court relief would not prove adequate. And I think there's no question that in this case, district court relief will not prove adequate. If we go to district court, we can't close one of these deals on a preliminary injunction. Play that out. Let's say a preliminary injunction issues, and it's in our favor. If we close in that situation, and a year later, this court decides we're wrong, we've done a disservice to that landowner. It is for precisely these kinds of cases, cases that the Attorney General agrees turn on legal issues alone, cases of statewide importance. This is whether or not the governor could administer this program that thousands of hunters and anglers rely on, that dozens of families rely on, that protects hundreds of thousands of acres in our state. It's those kinds of questions, when they turn on legal questions alone, that are appropriate before this court. The Attorney General didn't object to that in the brief. The Attorney General now comes to the court and says, well, because one of these deals was able to accommodate the court's argument, we should go back to district court. I think this court is empowered to decide this case now. I think this court knows the legal arguments both sides have made. And I think that if this court is faithful to its rules of statutory construction, there is only a single supportable reading of the phrase land acquisition. Now, finally, the point was made that there are different ways to diagram this sentence. And there is a very intellectually supportable reading that says that the phrase, or acquire easements upon, would completely sever the easement acquisition authority from the effect of this land board approval requirement. And that's a good argument. But we don't have to make it, because under the most demanding reading of the statute, on the assumption that land acquisition would apply throughout, it remains the fact that land acquisition requires the acquisition of land, and a conservation easement is not land. Unless there are further questions from the court? Thank you for your time, and thank you for the expedited consideration of this case. We urge a narrow holding that Section 87.12091 does not include conservation easements in the phrase land acquisition. Thank you.
So thank you very much to both counsel. This concludes the oral argument in this matter. We'll take it under advisement and get a decision in due course.